May it please your lordship. Lordship, I am craving indulgence of your lordship to kindly item number 8 to have some other day, your lordship.
Four, I think.
Four or
Four.
huh?
I think it's four.
Item number?
Four, your lordship. I'm sorry, item 4, your lordship.
Looking at where is it?
Lordship, item no.
I have no objection because, my lord, my learned senior, this is the first time in my career I've heard him taking adjournment.
So in view of that fact, we will give him 4 weeks. That's how long?
Let it be 2 weeks, your lordship.
On premier when still responded, seeking adjournment. The same not be objected to by petitioner. Matter is adjourned.
Apply, your
This is
lordship.
the out of 2 weeks.
Obliged.
My lord, in item number 3, my lord, we are required to file the written submission in the miss case, my lord. So we are filing it in course of the day, my lord. So my lord, may come up on Monday. We are filing it today, my lord.
On pre-made by the petitioner seeking some more time to file the
Respondent.
then a counsel for the to miss case.
And for the respondent in the miss case.
For the respondent has submitted that the written argument is ready but could not be filed today and has accordingly prayed for the matter to be listed on Monday, by which time this said written argument would have been filed. Pre-allowed. This is the same accordingly.
Obliged, my lord.
Obliged.
Please, your lordship, I beg to mention item number 5. I pray this matter may come after 3 weeks.
My lord, I'm for the state. I have no objections.
Actually, there's nothing left. I'm pre-made by the petitioner. List this matter to 3 weeks.
Deeply obliged.
Daily list, item number 1.
Your lordship, in this matter, we pray for some more time, your lordship, because we have not received instructions from the department.
What is this matter about?
My lord, this matter is about a default bail, my lord. We have filed
That calculation of the date.
technician, yes, my lord. So, my lord,
Why would you seek for time or seek instruction?
Your lordship, we are going to file an affidavit, so we need instructions from the department.
my lord, my only humble submission is that, my lord, I strongly object to that, my lord, to get time, because, my lord, this is firstly, it's a default bail application, my lord. And secondly, my lord, when this matter was listed in the previous bench, my lord, they have never sought for any prayer before the court that they will file the affidavit, my lord. But in fact, it was they have only sought time, my lord. So, my lord, kindly, if my lord permits to give them time, my lord, kindly grant them only 1 week time, my lord.
Lordship, 1 week will be too, lordship, because instructions take time, lordship, to come from the department.
See, I fail to understand what instruction is required. Again, we come back to the same issue. It's just a question of the calculation
Your
of
lordship,
the period. The only thing that you could do to satisfy this court is produce relevant authorities
Yes, my lord.
where there has been a precedent, or whether the law has been set. In 1 week's time.
your lordship, kindly grant us 2 weeks time, your lordship.
NDPS matter.
Yes, my lord.
Yes, lordship.
What is the quantity?
It's commercial quantity, my lord.
Commercial.
Yes, my lord.
So you have to overcome section 37.
Yes, my lord.
Even if default bill if it comes to default bill, that
Yes,
issue
my
would not arise.
yes.
This learned counsel appearing on behalf of the respondent has sought for time to file a response to this petition, for which the instructions have not yet been received. Though the prayer has been objected to by the petitioner, the learned counsel for the petitioner has, however, conceded to the extent that the said response be filed definitely within the next date fix. Considering the fact that this is an application for, you have prayed for grant of bail.
My lord, I've
What is
prayed
your
for
prayer?
quashing, to set aside the order, my
for
lord.
quashing.
Yes, my lord.
Oh, then.
To set aside the order dated 18/7/2024, 2023, my lord. Sorry.
Tapna asyik tu sini mo. On permit, this is matter after 2 weeks.
Highly obliged, my lord.
Item number 2.
Please, my lords, on the last occasion you were directed to file written arguments. My lords, kindly grant us some more time.
Why?
Lordship, in the course of the day.
Your Lordship, can you have order dated 26/7/2024?
Twenty-six.
26/7/2024.
Yes.
Last paragraph.
Yes.
Despite this, my lord,
Lordship,
is allowed to grant another 2 weeks time.
Lordship, we'll file it by the end of the day, in a day's time.
Your Lordship, in CRP 21 of 2016, Lordship, if I may be allowed to place the written arguments from the petitioner. We were supposed to file our written argument. If I may be allowed to place it before your Lordship.
No, let them file. See,
In the course of the day, my lords. In the course of the day.
we'll fix the matter on Monday.
Monday.
This learned counsel appearing for the petitioner in any area CRP 21. In 21.
Your Lordship, I'm for 21. Mr. Sir Kishore is for CRP 28.
In 20th, my lord, they have already filed their written argument.
You are appearing for petitioner in which case?
In CRP 21, Your Lordship.
21, exactly. There's no appearing for petitioner in 21. Has submitted that the written argument on behalf of the set of the petitioner has been filed today. Same is duly acknowledged. As far as you are here for respondent, as far as the written argument on behalf of the state respondent is concerned, Mr. Leonard G has submitted that the same may be allowed to be filed in course of the day. What about 28? 28?
Yeah, fine.
All are fine?
My lord, yes.
28 as prayed for. This is matter on Monday kira kan
On the 9th.
night.
Item number 6.
written arguments give course of the
ওই আলমিরা ইয়ে
okay.
সাইডে রেখে
Okay.
নিয়ে কম্পিউটার
From daily list, item number 1.
Yes. This matter has been heard.
Yes, yes, ma'am. That is a short matter only. This is an appeal, my lord, against the judgment dated 25/8/23, my lord, of the district session judge in the entire district, in which 3 were convicted on no reliable evidence and uncorroborated evidence. FIR, my lord, is in page 3 in English translation.
Yes.
Page 3, English translation. That on 1606 at 3 a.m. morning, one Brit-Sajam resident of Thatsning come and informed me that my brother, Sri Lobi Chulet, was pulled by unknown person. So me and my relative, we went in search of him, but instead we found him lying dead in the forest called H3. In this regard, we hope that you would be kind enough to help us. We shall ever remain grateful for their kindness. That is the evidence, my lord. That is FIR on page 3, my lord.
Yes.
Then, my lord, then in this case, my lord, 7 persons were examined. 7 persons were examined, and after that, and prior to that, of course, charge was free, my lord. The charge is on page. The charge under one head, my lord, on page 23-24, my lord.
What is the evidence collected by the IO against the?
In this case, my lord, he has examined 7 witnesses.
No, 7. The IO.
Examined 7 witnesses.
Okay.
7 witnesses. That is from page 25 to 41, my lord.
Oh, this is this the deposition or this is the 164 statement?
Deposition.
This is deposition.
Deposition.
Oh, see, Mr. Kanjing.
Yes, my lord.
The query of this court is this: the FIR would show that the so-called or whoever's involved in the alleged murder is not named, not known.
Not name.
So now it is incumbent upon the IO to collect the information,
Yes.
and on the basis of his investigation, he would find that there is a prima facie case
Yes. Yes.
well established against the accused. So that would be only in course of his investigation, and that portion would be found only in the charge sheet.
In the charge sheet, my lord. The charge
So
sheet is in
where is the charge sheet, which points to the complicity of the accused person?
Yes. The charge sheet.
Then after that, they would be put on trial, and the
Yes,
proceedings would follow.
The charge sheet, my lord, is in the charge is in one head, page 23 and 23, and the English translation will be 24. 23.
No, we are not talking about the framing of charge.
Yes.
Talking about the report under 173. Where's the report under 173?
Has been 303. Page 15. 1.5. 1.5, my lord.
I took a charge sheet naga record.
पीछे ना वाले
उनका charge sheet. You see what I want to know. Who are the witnesses who have been examined?
It's 46. The IO based on the from page 44 to 49, my lord. And the statement of the peacemaker, two witnesses.
Two witnesses.
The statement of two witnesses.
Oh.
44, and the type copy, my lord, is in 46, my lord. The deposition of one peacemaker Talang, my lord.
Yes.
Age about 43 years, taken on oath before me, P.L. Lawan, on 4th August I, Shri Peacemaker Talang, do hereby state that I witnessed the murder of Lubi Chelet by Shri Shemlang Langstang, Shri Tharling Langstang, and Shri Hierki Langstang at happening on 1606 at about 2 a.m. or 3 a.m. in the morning. The accused person had come to my place to drink liquor as to sell liquor. At first, Lubi Chelet and 3 friends came to my house, and after some time, the 3 accused came to buy liquor. They took it outside, and I thought that they had left. But after some minutes elapsed, they re-entered and forcibly took Lubi Chelet outside and assaulted him. Then they dragged him to a nearby forest and killed him. Page 46, my lord.
Yes, yes, please.
Afterward, they all came back to my house and apologized that they had to commit act while drinking in my house. They also said it was revenge for their late brother's death or murder at the hand of Ruby Chelet in the year 2004. That is a statement of Peacemaker Talang, my lord. And then also, and on the basis of statement of Wan Baha Lamari, page 49, my lord. Type copy. The deposition of Wan Baha Lamari, about 26 years taken on oath, under provision of Indian oath, so and so. My father's name is so and so. I, Sri Wan Baha Lamari, do hereby state that I witnessed the murder of victim Chulet by Sri Langstang and Sri Herki Langstang and Sri Herki Langstang, Thali Langstang, so on. I, along with the victim and another friend, had gone to the house of Sri Peacemaker Talang to drink liquor. As he said the same while sitting there, the three accused persons came and bought liquor, and we drank together. After some time, the quarrel caused between the victim Chulet refused to compromise with Chem Talang about the murder of Chem Talang brother by the victim Lubi Chelet in the year 2004. Chem Talang wanted to compromise, but the victim refused to, and out of anger, Chem Talang and the other two accused forcibly dragged the victim to a forest nearby to kill him. They rented the house afterward and uninformed us who are still inside of the misdeed. So on the basis of this two statements, my lord, of this PW1 and 2, under 164, they were arrested, my lord. Then along with them also they arrest another two accused also. They were arrested, the accused, as well as this PW1 and PW2 also were arrested.
Yes.
Yeah. That means total five accused. Five accused were arrested. However, my lord, by order 4E 2006, page 43, my lord. Forty-three. Yes. Accused person Chemlang Langstang, Thali Langstang, Herki Langstang, Peacemaker Talang, and Wan Baha Lamari are produced in court today after an expiry of 7 days in police custody. Seen the medical report of all the accused persons. Seen and perused the report of IO of the instant case. During the course in interrogation, while in police custody, it revealed the accused Sri Chemlang Langstang, Sri Tharli Langstang, Herki Langstang were directly involved and also confessed their physical involvement in the commission of the crime. Further, the IO reported from the statement of the involvement accused person and also from the evidence collected from Sri Peacemaker Talang and Sri Wan Baha Lamari are not involved in the instant case. That is, the IO reported that from the statement of the involvement accused person and also from the evidence collected from Peacemaker Talang and Wan Baha Lamari are not involved in the instant case. Hence, IO pray the court that arrested alleged Peacemaker and Sri Wan Baha Lamari may be discharged from the liability of the case and to approve them as a witness, as also to record the statement under section 164 CRPC. Further pray that the three involved accused cannot be remanded in judicial custody. Person be remanded in judicial custody for a period of 14 days to enable him to complete the investigation. Prayer aloud. The arrested alleged Peacemaker and Sri Wan Baha Lamari are hereby discharged from the liability of the case and approved as the witness of the instant case. Shri so-and-so to record a statement of the witness under section 164 CRPC. The involved accused person so-and-so are remanded till 17/18/26, my lord. So these two accused, my lord, peacemaker, PW1, PW2, initially they are accused, later on they are discharged and they will make accused, my lord. Or they will make approver.
They became approver.
Approver. They make approver. So that also I'll rely my argument also for that approver matter. So my lord, in this case, I'll start, my lord, from the informant, Barley Chulet, the brother of the deceased, who was not examined, my lord. He was not examined. And what is his role, my lord? Barley Chulet was only allegedly informed of the alleged incident by one Brit Sujem.
Yes.
By one Brit Sujem.
Yes. Where is it?
And that Brit Sujem also was not examined, my lord. From page 3 we can see that. So from the FIR it is very clear, my lord, that on 1606 at 3 in the morning, one Bridjan Sujem, resident Tasning, informed that my brother Levichilet was pulled and by unknown person. But this man, my lord, was not examined.
Yes.
This Bir Sujem was not examined. So this FIR, my lord, by Barley Chulen, but he was also not examined, and that Brit Sujem also was not examined.
But the fact remains that somebody has been murdered or somebody has been killed. He was found in the PO, and therefore the case was initiated.
Yes, my lord.
Who informs and what is the veracity of his information? That is, that's immaterial.
That's true, my lord. Because after all, FIR is only to move the machine.
Exactly.
But the fact remains, my lord, that he is not. That means he is not eyewitness. He is not. From it is very clear that he is not a witness of the crime, or from, and his knowledge also is only hearsay, my lord. Because after all, because
he was not examined. Was he examined?
He was not examined.
Then?
He was not examined.
Yes, please.
Now, my lord, I'll analyze the statement of PW1, my lord, peacemaker. Because this peacemaker, is 46, my lord. I, Shri Peacemaker, do hereby state that I witnessed the murder.
Page
46, my lord.
46.
That is statement under 164.
164.
Or it is a deposition before the court.
Oh, sorry, that is a deposition before the court, my lord. Deposition before the court.
Yes, we have gone through this. This is 164 statement.
Beg pardon?
Page 46 is 164 statement. You have read this.
Deposition. No. 27, my lord, deposition. Twenty-seven.
This is not the original form, this is a type.
27. Type copy 27, my lord.
Page 27.
27. 27.
Yes, one second, please.
Please.
Page 27.
27.
Yes.
Yes, PW1.
PW1 was recorded by the, at that time, of course, it's yet to be separated, so it was done by the ADM. I know the accused person who are present and appear in court today. I know one Loni Chulet. On 1/6/2006, the deceased Wet Sejem, Sukwan Lamare, came to my house for liquor and had liquor in my house, and thereafter came the accused person to my house for liquor. They asked for one bottle and took outside to have the same. The accused re-entered my house and started hitting Lobby Chulet with a stick once only. I object to the assault and told them to take him outside and don't beat him inside my house. Immediately after, I closed the door of my house. They took the deceased to H. Jungle. Afterward, Sri Herki Tharli came back to my house. Both of them asked for apology as they assaulted the deceased in my house and told me that he had murdered him. We killed him because he took a bench for he had killed our brother. That is his in chief, my lord. And in the cross, my lord, which is on page 28, he gave a different, he did not stick to his statement, my lord.
Yes.
It is a fact that before the police, I told that I came to know about the murder only on the next morning. It is a fact that I know about the murder from the public. It is a fact that I did not go with the accused person to the forest, and as such I did not see who murdered one to be Chalet. So, my lord, he is not eyewitness. And moreover, he did not know also, he knew about murder only the next morning, and he knew from the public. It is a fact I did not go with the accused person to the forest, and after this then I did not open my house except for Hierarchy and Langstang. It is a fact that before magistrate I stated that all of the accused person came back to my house after the incident. It is a fact that before the police I did not state the fact. So this is very important, my lord. Before the police I did not state the fact. It is a fact that the accused person did not inform or told me about the reason why they commit the murder. It is a fact that I wrongly deposed and stated that I witnessed the murder of one Lubichulet of the accused. So this is a very vital, my lord. It is a fact that I wrongly deposed and stated that I witnessed the murder of Lubichulet of the accused. It is a fact that before the police I did not state that the two accused has asked for apology as I assaulted the deceased in my house. It's a fact that before magistrate I stated that Lubichulet and three friends came to my house, where before the police I stated Lubichulet, one Bahalamari and Brit Sajem only came to my house. And this also another contradiction, my lord. Before the magistrate, I stated one Lubichulet and 3 friends came to my house. While before the police, I stated Lubichulet, one Bahalamari and Brit Sajem only came to my house. It's a fact that what I have stated before the police and the magistrate are contradictory, my lord. It is a fact that before the magistrate, I stated the accused person re-entered my house and forcibly took Lubichulet outside and assaulted him. While before the police, I stated that after giving liquor to the accused person, suddenly Herky Langston came inside my house together, along with his brother Tarly and Chamlang. Them without saying anything, Herky hit Sri Lubichulet with a stick to his head.
Yes.
So the statement in the cross, that means the statement the deposition is full of contradictory, my lord. Now, my lord, I'll come to one Bahala Mare, another PW2. He is in page 30, my lord. MD 31. One Bahala Mare. Page 31, my lord, and one Bahala Mare.
Yes.
I know the accused person who are present and in court today. I know one Lubichulet who is now dead. He died on 1/6/2006. At about 2 to 3 a.m., he was murdered by the accused person. I, along with Brit Sujem and the deceased, were having liquor in the house of peacemaker Talang. After that, the accused person came to the house of PW1 for drinking liquor for about a bottle in the veranda. Then again, they entered the house of PW1 and beat the deceased with a stick twice inside the house. Then they dragged him outside the house of PW1. Afterward, he met them and they told me not to tell others about incident. That is his in chief, my lord. In page 32, my lord, is the cross. In the cross, my lord, is stated, is the fact that I did not go along with the accused person to the forest, and as such, I did not see who murdered Sri Lubichulet. So this PW2 also he did not see. And he has stated also, it is a fact that what have been stated before the magistrate is not true. So this is also very vital, my lord. Both the PW1 and PW2 are stated like that. It's not true. It is a fact that I came to know about the incident only in the next morning, and it's not the accused person who informed me. It's a fact that the accused person entered the house of PW1 and assaulted the deceased with a stick twice inside the house, then forcibly took him outside. It's a fact that I did not state before the police that after the incident I met the accused, and also they did not tell me about the death of the deceased. It's a fact that I did not state the time or date when met the accused person, and as such I do not know where I met them. So, my lord, there is nothing clear from this PW2 also. So PW1 and PW2 who have been torn approval, my lord, by court order allowed to be so, they are the vital witness in this case, my lord. And their statement before the magistrate and before the IO also has stated that it is contradictory. Both of them are like that, say like that. And not only that, they say it's not true also.
This is not true.
Pardon?
They said that the murder is not true, or their statement is not true.
It's not true. It's no, not order. The deposition is a fact that what we have stated before the magistrate is not true.
Yes.
Not that. Okay, correct. So this, and if
No, reserve. This is just a moment. Reserve. Please continue.
so, my lord, if you go through the impugned judgment, my lord, they base only on these two witnesses, PW1 and PW2, who are the approver and who have their statement are contradict. Who are the approver and who their statement are contradict. And for that, my lord, I rely also in the Supreme Court decision, my lord, in
What about the other witnesses? They are not relevant.
nothing.
Nothing. Even the statement of IO?
Statement
Nothing is relevant, you want to say. That is your submission, is it that?
it come to that only, my lord, because after all, there is nothing.
Apart from these two,
There is no evidentiary on that.
Apart from these two witnesses, there is no other evidence to link the accused with the commission of the crime.
Yes, there is nothing. There is, and the other witnesses also.
And what is the finding recorded by the trial court?
There is
with regard to this
yes, I'll come to that, my lord. That is the vital thing for me. Regarding the other witnesses also, he stated that in his judgment that he was left no cross-examination. That means this correct. Actually, if you go through the statement of PW3, from top to bottom also, my lord, there is not anything evidentiary value. There is no evidentiary value. As such, my learned friend below in the court before the trial court did not cross him.
See, come to the fact of the murder. Where
Yes.
is the post-mortem report?
No, let me come also first, my lord, to that regarding the point of the contradict of these two witnesses, my lord.
Yes. Yes.
Because, my lord, I submit that the approver, their statement needs corroboration. And moreover, in this particular case, it is contradictory. And in this case, my lord, I rely in Sarwan Singh versus State of Punjab, 1957, my lord. Para 7, my lord. Para 7. No? In other words, the appreciation of an approval evidence.
Where you are reading? Para 7.
Para 7, my lord.
Para 7 starts with on behalf of so and so.
7 of 15, yeah. Last part, my lord. P7, my lord.
Yes, please.
Last two paragraph, my lord. In other words, the appreciation of an approvable evidence has to satisfy a double test. His evidence must show that he is a reliable witness, and that is a test which is common to all witnesses. If this test is satisfied, the second test which still remains to be applied is that approvable evidence must receive sufficient corroboration. This test is special to the cases of weak or tainted evidence like that of approval, because approval is a tainted evidence also, my lord. So in this decision of the Honorable Apex Court, my lord, his evidence must show that he is a reliable witness, and that is test which is common to all witnesses. If this test is satisfied, the second test will still remain to be applied with the approvable evidence must receive sufficient corroboration. There is no, as far as corroboration, there is zero. There is no corroboration, my lord. So why I submit, my lord, he is not a reliable witness. Right from the PW1 also, he has stated like that. His statement before the magistrate is one thing, and magistrate before the IO is another thing. So both of them are like that only, my lord. And there is no corroboration whatsoever, my lord. Now, my lord, I'll come to another citation, my lord. In Bhobani Sahu versus the King AIR 1949, Privy Council 257, my lord.
On the same point? Is it on the same point?
On the same, might be at some point also. You're going to repeat again. Page 4 of 8, my lord.
Para?
It's para 6, my lord. 4 of 8, para 6. Although the learned judges of the High Court, accepted the evidence. Last two lines, my lord.
Yes, yes.
Evidence of the approval given before the committee magistrate. They appreciate that it would be unsafe to act upon.
That is all right. There is no dispute to that proposition of law. I don't think these are all subtle proposition of law. You have given one decision. Do you need to give some more decision?
No, I'll not give them more. Also,
I don't think that what you say here, that the evidence of approval always need corroboration. That is the subtle law until and unless the other side shows something else. But then I don't think there is any dispute. This is also the same thing you are raising.
That is also this.
Why I press that matter? Because there is no other evidence.
That is all right. You have said it.
The learned session district and session judge rely only on this.
Yes, and your submission appears to be correct. Your submission appears to be correct. We do not know what they will point out, but then at this stage it seems like you are correct. What you say.
Now, my lord, I'll come to the injury caused under the disease, my lord. Page 65 is post-mortem, my lord.
Yes, just 1 minute. Yes.
Now, my lord, if you go to the post-mortem report also, it does not tally. In the post-mortem report, P65, my lord.
Any murder weapon seized?
Yes, ma'am.
You have seized?
This is a Dow.
Oh, Dow.
No. Then, my lord, here they say that P65 in the external appearance.
Yes.
65, my lord. The injury caused, as per the statement of PW1 and PW2, my lord, he was beaten with a stick. There is no injury in the except this cut wound, a big cut wound on the back and right side of the neck, 4 inches by 1 inches, bone deep cutting all the big blood vessel of the neck on the right side, my lord. That is the injury as appeared from the post-mortem report, my lord. But regarding other injury, there is no injury. All skull, vertebrae, membrane, brain and spinal cord healthy, my lord. So the statement of people 1 and 2 are not correct, my lord, because they say that they stated that the accused was hit with a stick. There is no hit with a stick. So the whole statement also, just like earlier, has become no value, my lord. Evidentiary value, as far as the crime is concerned, my lord, it has no evidentiary value to warrant conviction, my lord. I respectfully submit, of course, on that line. That's the thing. Because after all, this is a big cut wound on the back and right side of the leg. And moreover, my lord, in this case, they say that a material exhibit is a Dow. That Dow, my lord, there is no FSL report and no blood also to connect also the crime and the disease and the crime, my lord. There is no blood in the cloth on the body and the cloth of the accused person. Nothing, no connections whatsoever except this big cut wound. They say.
Where is the forensic report?
There is no FSL report. Yeah. There is no FSL report, my lord.
Yes, please continue.
There is no FSL report.
Anything else? Statement under 313?
313 is in page 68, my lord.
Yes.
Question number 1, my lord. It transfer from the evidence of PW1, peacemaker Talang, that he knows you were present in court. He know one lobby chulet. On 1/6/2006, the deceased Wet Sajam, Sakwan Lamare, came to his house for liquor and had liquor in his house, and thereafter you, along with your 2 other accused friends, came to my house for liquor. The 3 of you asked for 1 bottle and took outside to have the same. What do you have to say? It's a fact that I know Peacemaker. It's a fact that I know Peacemaker Talang, as he is my co-villager. It's not a fact that I, along with deceased, went to PW1 home for liquor. He has denied, my lord, that he went to the house of PW1. Then it comes to question number 2, my lord. It also transpired from the evidence of PW1 that the 3 of you again re-entered the house and started hitting Lobichulet with a stick once. He objected to the assault and told you all to take him outside and don't beat him inside the house. Immediately after he closed the door to his house, the 3 of you took the deceased to H-ray. What do you have to say? It's not true that it is not true, as I was not present at the PO. He is not present, madam. He is denied. It also transferred from the evidence of PW1 that afterwards Sriharki Tharli came back to his house. Both of them asked for apology as they have assaulted the deceased to his house and told him that both of them have murdered Sri Lobichulet. You all killed him because you took revenge that he had killed your brother. What do you have to say? I do not know whether Sriharki Tharli came back to PW1 and asked for apology and also murder that Lobichulet. But it's a fact that Lobichulet killed our brother. Then it comes to question number 4, my lord. It transpired from the evidence of PW2, Sri Wan Bahalamari, that he knows you were present in the court. He knew one Lobichulet. He died on 1/6/2006 at about 2 to 3 a.m. He was murdered by you. He, along with Bridget and the deceased, were having liquor in the house of Peacemaker.
Yes, Mr. Kinjing. Please come to page 71, question number 13. Your answer to question number 13.
Which
Page 71.
Yes, my lord.
Of the paper book.
Yes.
Come to question number 13 and the answer given there too.
It also transferred the evidence of PW5 that after investigation, he found premises can you and Thali Talang and Cherki Langstang and file against charge sheet so and so, byte so and so. He also prepared the sexual list of so and so. Exhibit 1 is a sexual exhibit list and exhibit 1 2 is signature material exhibit. In one Panada with a handle of 21 inches. What do you have to say? It's not a fact, as I was not involved in the case.
Yes, so that means you become involved. Read this kind of sentence, I'll reply carefully.
He has stated it's not a fact, my lord.
That I was not involved. That means he is involved.
That is a mere presumption, my lord.
What the sentence is, we are asking for the meaning of this.
That is a presumption.
Does it mean, you see, does it mean it? This sentence, what is the plain meaning of this sentence? Will come later. What is the consequence of admission or non-admission in 313? But then, what meaning it portrays? That is the main thing.
According to me, of course, denied. You was not involved in the case.
You are standing to defend him. What is the meaning of this sentence? I was not a fact. It is not a fact that I was not involved.
No, it's not a fact as I was not involved.
As I was not I was not involved.
As I was not involved.
Okay.
It's not involved. So, my lord, I have come to paragraph 6. It also transferred from the evidence bill 3 that his elder brother was murdered at Thangsning. What do you have to say? It's a fact that elder brother was murdered at Thangsning, as I heard it from my co-villager. I further transferred from the evidence of bill 3 that as soon as he came to know about the murder, he went to the place of the incident and found his elder brother Lobichulet was lying dead at the forest in Thangsning. What do you have to say? I have nothing to say. Then it further transferred from the evidence of PW1 Pilot 3, at the time that he reached the place of occurrence is about 9 a.m. in the morning. At the time he went to the place of occurrence, many persons in that place also found near the dead body of his elder brother, one Panardao. He does not know whether material exhibit is the Panardao. He does not know whether material exhibit is the Panardao used that he found near the dead body. So, but material exhibit one resembles one he saw near the dead body. I do not know. He transferred from the evidence of PW4, Sri Bajpar Paranki, that he knew the case as he accompanied the in-charge Narteng PSC to the PO, where a weaponer seized from the PO at Sasning. The dog was found and seized near the dead body, as he was signed on the sexual list. Exhibit 1 and Exhibit 1 by 1 is his signature. He seized the article the weaponer produced before the court today. He was said, "What do you have to say? I do not know anything about sexual." He has denied that also. Then he come to 10, my lord. It transferred from the evidence PW5, Chwanki Lamare. He knew of the case as he was IO. On 2/6/2006, he received an FIR from one Barlis Chulet or Tatsning to the effect that on 1606 at about 3 a.m., when Brit Sujem or Tatsning came to the house of complainant and informed that his brother Lubichile was drugged so and so, and he received and his relative each such Lubichile. They found that he was murdered at a place called Echre. What do you have to say? I have nothing to say. That means he is denied. So then 11, my lord. They also transferred from the evidence of PW5 that after receiving the FIR GD so and so, after receiving he went to Tatsning along with the relative of the deceased and hold in case about the dead body. He seized one dhow at the PO and examined such a witness, and the dead body was sent to Joy PS. What do you have to say? I have nothing to say. So they have nothing to say regarding the postmortem report. It also transferred on evidence PW5 that during investigation he came to know that there are 3 persons, Tarly, Hierarchy, 3 persons to you, that is you, Tarly, and Hierarchy, involved in instant case. Later, all 3 of you were arrested. What do you have to say? It's a fact that PW5 arrested us, but I was not involved. It is also transferred from the evidence of PW5 that after investigation, he found prima facie case against you, Sri Tarly Sutang and Sri Hierarchy Langstang, and filed against the charge sheet. He also prepared the sexual list by so and so. Sexual list and exhibit 1 by 2 is his signature. It's not a fact as he was not involved in the case. It also transferred to the evidence of PW5 that he identified you and Tarly Langstang, who were present in the court dock at the time he came to depose in the court. What do you have to say? I have nothing to say. Then 15, my lord, transferred from the evidence of PW6 Anthony Sutanga that he knew that instant case since at the 11th time he was the headman. So he just headman and he does not know. I do not know whether so and so was, as I'm staying in behind village. Then it also transferred from the evidence of PW6 that he knew the deceased person, also know that he belonged to the same village. What do you have to say? I know PW6 Anthony Sutanga as he came to my, as he is my brother-in-law. It also transferred the evidence of PW6 that on the day of the incident he was at the residence and suddenly one Barley came to the residence, and about 6 a.m. he informed him that his brother was murdered and requested him to report the matter to the police. But he did not report the matter. He did not report the matter to the police. On the same day, the police came to his residence, and he, along with the police personnel, went to the jungle where a dead body was lying. On reaching the PO, he recognized the dead body of Lubichile. I do not know, as we are of different villages. Then he come to 18, my lord. He transferred from the evidence of PW, that is a doctor, my lord. Then, regarding the postmortem, I have nothing to say. Do you have anything more to say? I was falsely implicated in the instant case. 20. Do you want to adduce evidence in your defense? Yes, my wife, Srimati Burra Rabban. Of course, there's nothing on record to show that she was called, my lord. Now, my lord, the alleged incident happened in the place of selling liquor, and I would respectfully submit, my lord, that in this case, my lord, in page 38, my lord, it is stated like this: it's a fact that the accused person was arrested after 1 month from their residence. Page 38 in the cross, my lord. This is the IO, my lord, Chwanki Lamare. It's a fact that the accused person was arrested after 1 month from their residence. It's a fact that there is no eyewitness in the instant case. However, on the day of the incident, the witness has stated that they saw the accused person drag the deceased from the house of Peacemaker Talang. It's a fact that Peacemaker Talang is one of the witnesses. It's a fact that during the course investigation, I went to the house of Peacemaker Talang and I recorded the statement at his residence. It's a fact that I have given prior information before I visit the house of Peacemaker Talang. It's a fact that though the wife, this is very vital, my lord, though the wife of PW1 is also present at the time when I visit the house, but have not made her as a witness, because it is alleged that the place of selling liquor is in his house only, and he has a wife, and that also was not examined, madam. I visited the PO only once on the day I received the information. I do not remember how many days the accused person was in police custody. I do not remember whether I have put it on record that the accused person stated that it belonged to him. This is IO statement, my lord.
Yes.
It's a fact that I have stated. It's what I remember, but I have not received it recorded in my CD. Yes. There's nothing recording in the case diary. It's a fact that after 9 years, I remember, though I did not put in record. It's a fact that during the investigation, the relative of the deceased person used to come to meet me. So, my lord, the IO did not examine also even the wife of the PW1 also. Now I would rely also in Pradeep Kumar versus State of Chhattisgarh, my lord. AIR online 2023 Supreme Court 309 para 24.
Para
24, my lord.
yes.
It is important to note that the cardinal principle in the administration of criminal justice in cases where heavy reliance is placed on circumstantial evidence is that where two views are possible, one pointing to the guilt of the accused and the other toward his innocence, the one which is favorable to the accused must be adopted, my lord. I respectfully submit, my lord, that there is nothing, that the conviction by the next session judge, madam, is not correct as far as this, because it is there is no evidence, and it's very much show regarding the innocence of the accused person. There is nothing whatsoever to show that they are. In the present case, with circumstances before taken together do not establish conclusively only one hypothesis, that being the guilt of the accused. The presumption of innocence remains in favor of the accused unless his guilt is proved beyond reasonable doubt against him, my lord. The cherished principle of golden thread of proof beyond reasonable doubt, which run through the web of our law, do not be stretched morbidly, which was done by the court below. So, my lord, in this it clearly shows that there is in favor of the appellant, my lord. So, in short, my lord, it is clear from that the prosecution lacked reliable evidence and was not proved that the offence and the appellant deserve acquittal, my lord.
What are the findings of the trial judge?
Judgment start from 74, my lord.
What are your grounds against this judgment?
In page 117, my lord, in order to confirm
Yes.
because now it is clear it's only circumstantial evidence, my lord. So 117, in order to confirm that the circumstantial evidence based upon which last-in theory is based passes the test of must be guilty and not may be guilty.
Yes.
Must be guilty and not may be guilty. The chain evidence pointing toward the guilt of the three accused persons, Sri Skemlangstang, Sri Tharki Langstang, and Sri Herki Langstang, are counted as hereunder. The deceased Lebichelet went to drink liquor on the same day on the house of PW1. The three accused persons, Sri so-and-so, was present in the house. Confirmed that the three accused persons were present in the house and they bought a bottle of liquor and consumed it outside the house. Thereafter, consuming the liquor, they entered again in the house and dragged the deceased so-and-so out. The entire incident took place at night. The evidence of PW3, Ebert Chulet, brother of deceased, PW3, PW5, who went to the place where the body was found lying, showed that the body was found in the morning. The deceased was killed between the time when he was last seen with the three accused persons, and this body recovered in the morning. The time gap between the deceased being last seen with the three accused persons and the death of the deceased is so less that there is no scope of any doubt that the deceased might have met any other person during the intervening period, or the author of the crime would be any other person other than the accused person. The fact that the deceased was dragged by the three accused persons also show hostility of accused person toward deceased Lubichulet. The postmortem report Exhibit 3 showed that it was conducted on 3/1/2006. The body was fresh. Finally, the body was found with an injury on the vital part of the body, that is in the neck, caused by a sharp weapon, and the weapon was recovered near the body and was seized by Exhibit 1. The three accused person who has failed to keep any explanation under Section 313. The sequence of events which has unfolded from the presumption evidence that the deceased went to drink liquor at the house of people when the three accused persons arrived. They strapped the deceased with a string. Thereafter, the person entered the house and dragged the lubricant outside the house. On the following day, the dead body of the deceased was found in the jungle with injuries in the neck, with a nardow lying beside him. The above chain of evidence is conclusive in nature and form complete chain, leaving no room for any reasonable ground for the conclusion consistent with the innocence of the accused person. This could reiterate that the test arrived at the conclusion and probability of the conclusiveness of the prudent man and not with the legal mind, or prudent man and not with the legal mind. This could reiterate that the test arrived at the conclusion and the possibility and the probability of conclusiveness of a prudent man and not of a legal mind. Presumption has established that the deceased was last seen with the three accused persons. So, my lord, from this is the thing that she based, that the learned session judge has convicted.
Circumstantial evidence based on the last seen theory.
Yes, my lord. And the last seen theory also is not clear, my lord, because last seen theory, that means by PW1 and PW2 themselves, and PW1 PW2 has indicated clearly that they are not reliable witness, my lord. They are not a reliable witness. The statement before the magistrate, statement before the IO, also are not reliable, and it was contradictory, my lord. They are not a reliable witness, my lord. That's why, my lord, I rely on that judgment that the possibility that they are innocent also is heavily weighed on them also, because after all, it's a place where they are selling liquor, and it is. That's why there are many people also. This man know this PW1 and PW2. From that angle also, my lord. Otherwise, there is nothing to indicate. That's why they say it's important to know that the cardinal principle in the division of criminal justice, in cases where heavy reliance is placed on circumstantial evidence, is that where two views are possible, one pointing to the guilt of the accused and the other toward his innocence, the one which is favorable to the accused must be adopted, my lord. So I respectfully submit, my lord, that the appellant are not are entitled, that they are not involved in the crime, my lord. So in view of this citation also, my lord, that the cherished principle of golden thread of proof beyond reasonable doubt. So in this case, my lord, there is nothing which proof beyond reasonable doubt.
In your 313 statement, was any situation put to you that you were seen together with the victim last?
No, I think no.
Any question put to you in that line, that as far as so and so you were last seen there with such and such thing? No.
It's not there, I think. If I don't remember, it's there. Which another? In that is done by only by PW1 instead, my lord.
About yourself and completely different thing that you are seen together. You have not denied it. If the court has not presented that line, if the evidence has not proceeded in that line, if the evidence was basically the purpose of proving that they have committed the crime and that the crime, yes, and if they fail to prove it, then how can the court later return with their evidence into the court? I'm just saying that if this blank that is not
Yes. Anything else?
In this, regarding that, my lord, question number 1, it transpired from the evidence of Pilu 1, Sri Peacemaker Talang, that he knows you who were present in court. He knows one Labi Chulet. On 1/6/2000, the deceased Sir James so came to his house for liquor and had liquor in his house, and thereafter you, along with two other accused friends, came to his house for liquor. The three of you asked for one bottle and took outside to have the same. What do you have to say? And his reply is that it's a fact that I know one Peacemaker Talang, as he is my co-villager. To that extent, he said that
That
he
is
knew
with,
him.
with regard to the peacemaker is the witness.
He's a witness.
What about the victim? He know nothing. He did not say anything.
He didn't say anything. He just say he know one to be cheated. He didn't say that there's not sure that they are having liquor together, madam. Nothing. That will one. There's nowhere in statement. There's no word that they are having drink together.
And the place of occurrence, was it a place for selling liquor? It is a house or something.
In the house, madam.
It was a house.
In the house.
It was not open to customers,
It's open to customer, but it is they are selling like that only. It's not a.
So the evidence doesn't say that apart from the presence of the accused and the victim, there was no other person present. So it is not that only this accused and the victim, they were present in the place of occurrence or in the shop.
No, the people come and go.
Yes, so
come
that
and
is all. So there is no evidence to that effect.
No evidence. They come and go.
Because since the trial court has applied that lasting theory here, now for making this lasting theory applicable, which makes an accused, normally in the criminal law, the accused doesn't have to explain any situation against him. But then in certain situation, when this lasting theory is applied, then the law requires some kind of explanation from the accused also to explain the situation. If his presence is proved at the place of occurrence.
His presence was not proved.
So that is way.
They have denied that they went there.
We see that the trial court has applied it. The lasting theory to sustain the conviction. So
yes, anything else?
There is nothing to show that we were there.
Now, this lasting theory is the only basis of conviction.
Yes, madam. That's the only reason. So it is a very doubtful, and moreover, it's not beyond reasonable doubt, madam.
We'll look into that aspect. Continuing on that. As you will take. Yes.
Lordship, if I may seek time to reply, because it'll take some time for my reply, Lordship, but I don't have my case laws with me today, so I pray that I may reply on the next day, Lordship.
Okay. Heard. Yes, Kenjing Larat, Senior Counsel, appearing for the appellant. The argument of the appellant is concluded. Ms. Angela Larat, Senior GA, appearing for the state respondent, has, however, sought for time to reply to the argument of the appellant. We meet the seems along. This is matter 2 weeks.
My lord, I pre-indulgent just clarification. that it is a place where people come to purchase. And at that particular time also, the statement of PB1, three people also came, 3 friends are also there, and none of those people were there for to examine.
You are not made witnesses.
They don't seem to be. They don't appear to be made witnesses.
But then, what is the consequence of that? If they are not made witnesses.
Then we know it's an independent witness.
Law doesn't always require independent witnesses, does it?
No, but if you don't examine them, my lord, then where is the connection that these other people also are there?
If you say certain thing is not proved,
they are not proved.
Because non-examination of some, you see, relevant witnesses, that is one argument. But then if you say that there are a number of witnesses involved and only 2 were picked up, others were not examined, that cannot be a ground. It is not the, you see, like the quantity of witnesses. It is the quality of witness.
That's true.
If the evidence covers every aspect. But then as of now, you have shown us many things which prosecution will have to reply. You have to see which way the class thing theory is applied and all. So that is what we have to see.
Okay,
so next date.
Much obliged, Lordship.
Item number 5.
My lord, this is an application under section 21, my lord, of the National Investigation Agencies Act, my lord. We are challenging the impugned order passed by the special judge and I, rejecting our bail applications, my lord. Here, my lord, my first ground, there are 2-3 grounds on the basis of which I am challenging the order, the impugned order, disallowing my bail application, my lord. The first thing is, my lord, there are 9 persons charge sheeted, my lord, in this case, my lord. And out of these 9 persons, my lord, 3 of us, my lord, we are charged under the same offense, my lord. That is section 120B and section 120B of the Indian Penal Code and section 6 of the Explosive Act, my lord.
Mr. Yubin, should we continue in the second
Yes,
half?
my lord. Second half, my lord. Yes.
You don't have any-
Second half, my lord. Okay.
Item 6.
Lordship.
Here also same thing is the order is there.
No, Lordship, but
Yes, Mr. Dr. Mazika. Look at the last order.
You've done the correction. You've done the correction.
You've done.
Lordship, just in the morning itself, it was, Lordship, we were under the impression that a fresh affidavit will be filed, Your Lordship.
Only the name of the Chief Justice, my lord.
But Lordship,
Only name of Chief Justice was changed.
Lordship, we were under the impression that a fresh affidavit will be filed, Your Lordship. So, Lordship, if they were relying on the same affidavit, Your Lordship.
I think a little bit. Because what happened was we sent the affidavit after drafting, my lord. The then Chief Justice was there, so we wrote the name, my lord. In the meantime, by the time affidavit came, so we had to do the change. We have done that one. But that will not change the content of the affidavit.
If that is not the case, then Mr. Yubin, you don't have any objection to that?
No, I have no objection, my lord. I am more concerned about a young 24-year-old boy languishing for about 900 days, my lord. I am more concerned about that.
Are the 2 matters are connected? The same case?
No, a different case. One is police bazaar blast, my lord, and the other is kidnapping in St. Tales, my lord.
Okay.
So, Lordship,
okay. But in both cases, in both the cases, you have sought for correction.
Right.
Lordship, if I may humbly pray, Lordship, let the matter come tomorrow or Monday, Lordship. Item 6.
Dr. Mojika will not have any objection against the prayer of adjournment.
That is for item 6.
Item 6, Your Lordship.
In that case, if number 5 also, if you can accommodate one day.
5 tomorrow, my lord, because
Tomorrow, I'm praying
here,
tomorrow.
my lord, 24-year-old college boy, my lord, alleged of supplying arms only for 2,500 rupees. All the other accusers are enlarged on bail.
Come near. Why you are speaking from behind?
Sorry, because the other, I'm sorry, my lord. Yes. So, if that be the matter, my lord, if not tomorrow, my lord, in the second half.
We will take it Tuesday. We'll take it on Tuesday.
Tuesday, 10th. Oh, my lord, Tuesday 10th, oh, my lord.
Made by the parties. This is matter on 10th. Yes, same order.
Both the matters.
And be prepared.
Obliged.